a fearless attorney steps into the Supreme Court, facing a Chief Justice's scathing rebuke. But what she unveils next stuns the bench, rewrites history, and shakes the foundations of American law. The heavy mahogany doors of the Supreme Court's grand chamber swung open with a resonant thud, their weight echoing the gravity of the moment. Pam Bondi, former Florida Attorney General, strode forward, her measured steps a cadence of resolve as she approached the podium facing the nation's highest judicial tribunal. Her navy suit, crisp and commanding, stood in stark relief against the somber black robes of the 9 justices seated before her, their gazes a gauntlet of scrutiny. At the center loomed Chief Justice John Roberts, his typically composed expression replaced by a piercing look of unmistakable disapproval. The air crackled with tension as Roberts's voice cut through the hushed chamber, each word a thunderclap. "Ms. Bondi," he declared, his tone sharp and unyielding, "before you utter a single argument, I must address a glaring procedural irregularity in your filing. This court upholds rigorous standards, and your unorthodox approach to precedent citation has sparked grave concerns among several justices on this bench." The gallery of legal scholars, reporters, and observers leaned forward, their collective breath held in suspense. Chief Justice Roberts rarely opened oral arguments with such a direct and blistering challenge, his words signaling a storm brewing for Bondi's case, a high-stakes constitutional showdown poised to redefine the balance between state sovereignty and federal power. Bondi stood motionless at the podium, her face an unreadable mask of calm, even as Roberts pressed his critique with unrelenting precision. "Your brief invokes what you term implied presidential authority in a manner this court has never sanctioned," he continued, brandishing her filing, its pages marked with vivid yellow highlights. "Moreover, your entire argument hinges on a constitutional interpretation that appears to brazenly defy our ruling in Henderson versus Department of Commerce from last term." Justices nodded in quiet agreement, Elena Kagan whispering to Sonia Sotomayor, who frowned as she scanned Bondi's brief. For most attorneys, such an opening salvo from the Chief Justice would herald certain doom. But those who knew Pam Bondi, her meticulous preparation, her razor-sharp legal mind, her decades as Florida's fearless top law enforcer, saw the subtle confidence in her stance, the faint glimmer of resolve in her eyes. As Roberts concluded his rebuke, the chamber waited, breathless, for her response. With deliberate calm, Bondi opened her leather portfolio, her movements steady, almost ceremonial. What she revealed next would not only silence the Chief Justice's criticisms, but unleash a legal earthquake, reshaping constitutional law for generations. The document she held, hidden from public view until this precise moment, was a masterstroke so audacious, so brilliantly conceived, that even her adversaries would later marvel at its genius. This wasn't just an argument. It was a historic reckoning, a clash that would echo through the ages. Before we unveil the seismic twist that turned the Supreme Court on its head, smash that like button, drop your location in the comments, and subscribe for more heart-pounding legal and political analysis that mainstream media dares not touch. Now, let's plunge into the saga of how Pam Bondi faced down the nation's highest court and changed history. The Supreme Court chamber was a crucible of power, its marble pillars and crimson drapes framing a battle that transcended law, probing the very soul of American governance. To grasp the magnitude of this moment, we must first meet the titans at its core. Chief Justice John Roberts, the court's meticulous steward, and Pam Bondi, a legal warrior whose career was defined by fearless precision. Their collision was more than a legal dispute. It was a test of constitutional fidelity, a showdown that would determine who truly holds the reins of power in America. John Roberts was no ordinary jurist. Appointed in 2005 and confirmed as the 17th Chief Justice at just 50, he'd forged a legacy as a brilliant legal mind, his command of constitutional law matched only by his commitment to the court's institutional integrity. At 68, with salt and pepper hair and a gaze that could pierce steel, Roberts was a figure of gravitas, respected across ideological divides yet scrutinized for his nuanced rulings. His preparation for Commonwealth of Florida versus Federal Environmental Regulatory Commission was exhaustive, driven by the case's profound questions about federalism and executive power. His opening challenge to Bondi wasn't mere posturing. It reflected a deep concern that her approach threatened the court's sacred precedent. Before him stood Pam Bondi, a formidable force at 58, her blonde bob and steely demeanor a hallmark of her storied career. A two-term Florida Attorney General, she'd argued before the Supreme Court with surgical precision, earning admiration for her commanding presence. With a University of Florida law degree and over 20 years as a prosecutor, Bondi was no stranger to high-stakes battles, her strategic brilliance often catching opponents off guard. After serving as a special presidential advisor, she'd returned to private practice, focusing on constitutional challenges to federal overreach. In this case, she wasn't just defending Florida. She was championing a vision of governance rooted in state sovereignty, a cause she'd fought for decades. Her calm at the podium belied a mind racing with strategy, her every move calculated to shift the legal paradigm. The case itself was a colossus, its implications reverberating far beyond the courtroom. Florida had challenged the Federal Environmental Regulatory Commission's authority to impose emission standards on state power facilities without explicit congressional approval, raising existential questions about executive agency power and federalism. At stake was not just environmental regulation, but the broader framework governing countless federal rules across industries, energy, healthcare, finance, and more. Legal scholars hailed it as the most significant federalism case in decades, with Harvard's Noah Feldman calling it a potential turning point in the constitutional dance between states and federal agencies. The Wall Street Journal's front-page headline screamed, "Supreme Court to decide who governs American industry." Amicus briefs poured in from business groups decrying regulatory overreach and environmental advocates defending national standards. The chamber was packed. With state officials, industry leaders, and activists, every seat in the press section claimed by reporters from global outlets, their pens poised to capture a historic moment. For Bondi, this was the culmination of her life's work, a chance to cement her legacy as a defender of constitutional limits. Her approach, which Roberts had publicly skewered, was no accident. It was the product of months of relentless preparation, a bold reimagining of legal precedent. As Roberts's critique hung heavy, Bondi knew the next 30 minutes could reshape American law. "Thank you, Mr. Chief Justice, and may it please the court," she began, her voice steady yet infused with quiet defiance. "I welcome your concerns about our approach and am eager to address them head-on." Roberts raised an eyebrow, expecting retreat, but Bondi's calm acknowledgement signaled something else, a lawyer ready to turn the tables. "Before diving into the substantive constitutional questions," Bondi continued, her tone measured but resolute, "allow me to clarify what seems to be a misunderstanding about our citation methodology." She opened her portfolio with a deliberate flick, revealing a dark blue document, its presence a quiet anchor in the storm of scrutiny. The court's concern focuses on our reference to implied presidential authority. Let me be clear, this isn't an attempt to invent precedent, but rather an articulation of a specific analytical framework this court has applied across multiple rulings, though never formally labeled. Justice Samuel Alito leaned forward, his skepticism sharp. "Ms. Bondi, are you suggesting we've been applying a doctrine without naming it ourselves?" Bondi met his gaze unflinchingly. "Not quite, Justice Alito. I'm submitting that this court has employed a consistent approach when resolving conflicts between state sovereignty and federal regulatory power, a pattern not yet unified under a single doctrinal name. Justice Elena Kagan cut in, her voice a honed edge. Ms. Bondi, this feels like cobbling together convenient excerpts from opinions while dismissing their contexts. Bondi turned to Kagan, her respect unwavering yet firm. I hear your concern, Justice Kagan, and I assure you that's not our aim. She produced a second, weightier document from her portfolio, its pages a fortress of scholarship. We've prepared a comprehensive analysis tracing this reasoning through 42 Supreme Court cases over the past 4 decades, revealing a consistent analytical thread when opinions are examined in their entirety. Copies were distributed via the clerk, Roberts accepting his with a deepening frown, his eyes darting to the executive summary as justices exchanged intrigued glances, the chamber humming with anticipation. Additionally, Bondi pressed, her voice now a crescendo of conviction, our perceived deviation from Henderson versus Department of Commerce is not a defiance but a distinction grounded in a pivotal factual nuance the court itself underscored in footnote 23 of that opinion. Justice Sonia Sotomayor shook her head, her tone skeptical. Ms. Bondi, these regulatory mechanisms have been in place since the 1970s. Are you asking us to unravel half a century of settled practice? The room tensed, reporters' pens racing, the weight of Bondi's challenge to entrenched precedent electrifying the air. Justice Sotomayor, Bondi replied, her voice a beacon of, resolve. Mere longevity does not bestow constitutional validity. This court has never shied from righting wrongs, as it did when Plessy versus Ferguson stood for 58 years before Brown versus Board of Education. A collective gasp rippled through the gallery, justices visibly startled by the bold parallel, their expressions a mix of shock and contemplation. Roberts intervened swiftly, his voice a stern admonition. Ms. Bondi, equating environmental regulations to segregation is inappropriate. Bondi's response was immediate, her tone conciliatory, yet unyielding. My deepest apologies, Mr. Chief Justice, if my example was misread. I sought only to highlight that this court has long recognized when precedent must yield to constitutional truth, regardless of its tenure. The chamber remained charged, the stakes palpable as Bondi turned a page in her notes. If I may, I'd like to pivot to the heart of this constitutional dispute, which extends far beyond this regulatory matter. Roberts nodded, his expression still cautious, a silent dare to justify her audacity. Bondi paused, her gaze sweeping the bench, the weight of the moment hers to command. This was her crucible, the point of no return. She reached for a third document, bound in rich crimson leather with gold embossing, its presence a silent herald of revolution. Your Honors, she declared, her voice now infused with a solemn authority that silenced the room. In preparing this case, we unearthed something extraordinary, a discovery that bears directly on the issue before us and the foundational principles of our Constitution. The justices leaned forward, their attention absolute, as she opened the volume with reverent precision. What she was about to unveil would redefine the legal landscape, a revelation poised to alter history. Mr. Chief Justice, members of the court, Bondi began, her words resonating with quiet power, what I hold has, to our knowledge, never surfaced in any previous litigation. She turned to a marked page, her tone measured yet commanding. This is the personal journal of Senator Prescott Wald, chairman of the Senate Committee on Interior and Environmental Affairs, from 1969 to 1973, during the drafting of the Environmental Regulatory Authorization Act. A murmur of astonishment swept the gallery. Wald was the statute's mastermind, his papers locked in obscurity until Yale University's archives unsealed them 6 months prior. These journals, Bondi explained, her voice steady, contain Wald's contemporaneous notes from closed-door committee sessions, capturing the intended scope of regulatory authority, details deliberately excluded from the public legislative record? Justice Amy Coney leaned forward, her voice thoughtful but guarded. Ms. Coney, legislative history can guide us, but this court treads cautiously with materials beyond the official record. Bondi nodded, her response precise. I respect that caution, Justice Coney. These aren't mere reflections. They're official working papers documenting verbatim negotiations over the statute's text, including its explicit constitutional boundaries. She turned to a page marked with a crimson ribbon. On April 7, 1971, Wald recorded, "Today, we finalized Section 5B, ensuring state implementation plans take precedence. Federal standards are to guide, not dictate, absent specific congressional approval for each major regulatory domain." The chamber fell into a profound silence, Wald's words a sledgehammer shattering decades of regulatory assumptions. Bondi continued, her voice rising with urgency. 2 days later, Wald noted a discussion with Senator Harlan, the ranking minority member, who feared future administrations might overreach. They agreed to add clarifying language in subsection D to cement this limit. Roberts interjected, his tone probing yet intrigued. Ms. Bondi, how does this square with Henderton's framework? Bondi was prepared, her reply a masterstroke. Mr. Chief Justice, Henderton presumed Congress intended sweeping regulatory power. These documents directly undermine that assumption for this statute. She turned to another marked page. On May 12, 1971, Wald wrote, "Our counsel emphasized that requiring congressional approval per regulatory category ensures constitutional fidelity, preserving legislative accountability against unchecked executive action." Justice Kagan interjected, her skepticism honed. Ms. Bondi, even if authentic, do these notes reflect only one senator's perspective? Bondi turned to the final page, her voice unwavering. A fair question, Justice Kagan, but on June 10, 1973, Wald recorded, "Before the committee's final vote, I read the constitutional limits into the record, securing unanimous agreement that federal authority hinges on explicit congressional action. All members endorsed this as the Act's constitutional keystone." She closed the journal with a soft thud, her words ringing out. This wasn't one man's view. It was the collective intent of the drafting committee, obscured as agencies expanded beyond Congress's vision. The justices exchanged glances, the gravity of Bondi's revelation dawning. The Solicitor General, visibly shaken, scribbled furiously. Roberts broke the silence, his tone now reflective. "Ms. Bondi, why was this absent from your original brief?" Bondi's response was calm, assured. "Mr. Chief Justice, the Wald papers were declassified 4 months ago. We uncovered their relevance during preparation and filed a supplemental authority letter 2 weeks prior." Roberts nodded, recalling the notice, his initial rebuke softened by contemplation. "These documents introduce a compelling new dimension," he said. "While we must verify them, they offer context unavailable in Henderton." Bondi nodded respectfully. "Thank you, Mr. Chief Justice. We've submitted authenticated copies to the clerk." As she stepped back, the chamber was transformed, the confrontational air replaced by a hushed reverence. What began as a judicial reprimand had become a historic pivot, Bondi's evidence reframing the court's understanding. The aftermath was a legal and cultural cataclysm. The court ordered supplemental briefing on the Wald papers, a rare move signaling their impact. Outside, reporters mobbed analysts, CNN's correspondent proclaiming, "Bondi turned a judicial dressing down into a constitutional revelation." Yale confirmed the document's authenticity, igniting academic fervor. The Wall Street Journal's headline blared, "Bondi's archival coup could redefine federal authority." Bloomberg Law outlined impacts across sectors. SCOTUSblog.com praised Bondi's legal artistry, while Harvard's Noah Feldman wrote, Bondi's timing was surgical, leveraging Roberts's challenge to amplify her evidence's adi force. Political shockwaves followed. Congress scheduled hearings, Senator Elizabeth Warren tweeting, "Congress must act to clarify regulatory powers." Industry groups celebrated. Environmentalists called for legislative fixes. 2 months later, Roberts's 7-2 opinion, citing the Wald Papers, ruled the regulations exceeded statutory bounds, establishing a new test requiring clear congressional authorization. The Wald Papers, he wrote, illuminate Congress's constitutional design, lost to administrative overreach. Bondi's victory became legend, her name etched in legal history. Law schools launched symposia, firms vied for her expertise, and governors courted her. Her sole comment was understated. The Wald Papers speak for themselves. I trust the court weighed them justly. The saga redefined administrative law, a monument to one woman's brilliance. Like, subscribe, and comment. What's the balance between Congress and agencies? Join us for more battles shaping America's destiny.